ল ব্যারেট রেজিস্টার্ড আইনি প্রতিষ্ঠান। আমরা সুপ্রিম কোর্ট, হাইকোর্ট, জেলা কোর্ট, ক্রেতা সুরক্ষা আদালত প্রভৃতি কোর্টে যে কোনো আইনি সমস্যায় আপনাদের পাশে সর্বদা। ল ব্যারেট ল ফার্মের তরফ থেকে আজকে যে ভিডিওটা দেখানো হচ্ছে সেই ভিডিওটা খুবই ইন্টারেস্টিং ভিডিও। পুরো ভিডিওটা প্রথম থেকে শেষ অবধি দেখার জন্য অনুরোধ করা হচ্ছে। আজকের যে বিষয় সেটা হচ্ছে আস্কিং ম্যারিড লেডি to do household work for family is not an offence. Household work for family is not an offence. High Court quashes 498A IPC case. Recently, the Bombay High Court ruled that if a married lady is asking to do household work definitely for the purpose of the family, it cannot be said that it is like a maid servant. The bench of Justice Viva Kankanwardi and Rajesh S. Patil was dealing with the application filed under section 482 of the CRPC for quashing the FIR registered for the offences punishable under section 498A, 323, 504 and 506 read with section 34 of Indian Penal Code. In this case, applicant number 1 is the husband of respondent number 2. Applicant number 2 is the mother of applicant number 1 and mother-in-law of respondent number 2. As per the wife, that is respondent number 2, she was treated properly for about a month by the applicants and thereafter she was treated like maid servant. The application started demanding an amount of rupees 4 lakh for purchasing four-wheeler. When she told that her father does not have that much amount, then applicant number 1, that is husband, had harassed her physically as well as mentally. The issue for consideration before the bench was whether the applicants are liable to be convicted under section 498A, 323, 504 and 56 read with section 34 of Indian Penal Code. High Court stated that if a married lady is asked to do household work definitely for the purpose of the family, it cannot be said that it is like a maid servant. If she had no wish to do her household activities, then she ought to have told it either prior to the marriage so that the bridegroom can rethink about the marriage itself, or if it is after marriage, then such problem ought to have been sorted out earlier. The bench noted that in the FIR as well as the statements of the witnesses under section 161 of CRPC, it is stated that after 1 month of our marriage, the husband started demanding amount of rupees 4 lakh for purchasing four-wheeler. When she had stated that her father does not have amount, it is stated that applicant number 1 had harassed her physically and mentally. Again, the details are lacking. Mere use of the word harassment mentally and physically are not sufficient to attract ingredients of section 498A of Indian Penal Code. Unless those acts are described, it cannot be concluded that whether those acts amounted to harassment or subjecting a person to cruelty. Trend that asking married lady to do household work for family is not an offence, High Court quashed. Recently, the Bombay High Court ruled that if a married lady is asked to do household work definitely for the purpose of the family, it cannot be that it is like a maid servant. After that, again the details of lacking, mere use of the word harassment mentally and physically are not sufficient to attract ingredients of section 498A of IPC. Unless those acts are described, it cannot be concluded that whether those acts amounted to harassment or subjecting a person to cruelty. High Court opinion that when in this case the allegation those have been made and the collection of evidence is not sufficient even at the prima facie stage to attract the ingredients of offence punishable under section 498A of Indian Penal Code. Further, as regards offences under section 323, 504, 506, read with section 34 of Indian Penal Code is concerned, it is in fact already conferred under section 498A of Indian Penal Code, and unless those other offences are shown which would amount to cruelty, offence under section 498A of Indian Penal Code cannot be made out, and therefore it would be a futile exercise to ask the applicants to face the trial. In view of the bench allowed the application. Case title: Sarang Diwakar Amle versus State of Maharashtra. Bench: Honorable Justice Viva Kankanwadi and Rajesh S. Case number: Criminal Application number 40 of 2021. থ্যাংকিং ইউ অল। ল বার্টের তরফ থেকে এই ভিডিওটা দেখার জন্য অসংখ্য ধন্যবাদ। ভিডিওটা ভালো লাগলে অবশ্যই লাইক করুন, চ্যানেলটা সাবস্ক্রাইব করুন এবং প্রচুর শেয়ার করুন যাতে অন্যান্য দেখে উপকৃত হয়। এই সম্পর্কিত লিগাল অ্যাওয়ারনেস কিংবা ইনফরমেটিভ ভিডিও পেতে চ্যানেলটা সাবস্ক্রাইব করে রাখুন, তাহলে সবার আগে যখন ভিডিও আপলোড হবে আপনাদের স্ক্রিনে পৌঁছে যাবে। আর আপনাদের যদি এই বিষয়ে কিছু বলার থাকে, এই সাবজেক্টের উপরে কি অন্যান্য সাবজেক্ট জানার ইচ্ছে থাকে, তাহলে অবশ্যই কমেন্ট বক্সে কমেন্ট করুন। ধন্যবাদ।